Hello everyone, and welcome to this Fieldfisher Live webinar on balancing data protection and safety obligations across the EU and China during and as we emerge from the COVID-19 crisis. My name is David Lorimer, and I am a director specialising in employment and privacy law in the UK. Thank you so much for joining us. Thank you also to Fieldfisher Italy for organising and hosting, and to my very talented colleagues from around the world for joining. COVID-19 has fundamentally changed the way that the workplace looks and feels. Concerns about containing the spread of the disease and looking after the health and safety of employees and visitors are paramount in employers' minds. We're receiving an increasing number of queries from our clients on such issues as testing and monitoring employees' temperatures, sickness reporting and disclosure of COVID-19 diagnoses to colleagues as part of efforts to trace and limit the spread, and in some countries, the role of the company physician or other healthcare professional in processing employee data. We will hear from Fieldfisher's privacy experts in Italy, France, the UK, Germany, Spain, and China, who will offer their insights on these questions and the approach of their data protection authorities to help you manage and navigate these issues at this difficult time. We will finish at 12 noon CEST. Before we come on to the substance, I have a few points about us and also a few housekeeping points about the webinar. For those of you that do not already know us, Fieldfisher is an international firm with offices across Europe, in Silicon Valley, and in China. And our privacy team works across all of these offices. We are a collaborative team providing strategic and actionable privacy solutions. I know you're going to hear about that in this webinar. As you will know from the invite, we have assembled a cast of excellent speakers today, including Francesca Gravili, a partner in our Italian privacy team, Olivier, a partner in our Brussels-based privacy team, who focuses on French data protection law, Thorsten Ihler, a partner in our German privacy team, Manuel Alonso, a partner in our Spanish privacy team, and last, but certainly not least, Zhaofeng Zhou, the managing partner of Fieldfisher China and the data protection specialist there. We particularly look forward to hearing Zhaofeng's unique take on the issues, given GDPR, which in theory unites the rest of us, does not apply in respect of the issues as they arise in China. And of course, Chinese workplaces are at a more advanced stage of their return to normal working life. I know from experience of working closely with each of them that they are hugely talented and solution-focused, and I look forward to hearing from all of them. Later today, or perhaps early next week, we will send you a recording of this webinar, so do not feel like you have to make lots of notes as we go along. One final piece of housekeeping. Unfortunately, because of the number of panelists we have and the issues we're tackling today, we will not be able to take live questions today, but we have identified a few questions that we are seeing in practice and which some of the attendees have raised in advance, and we'll look to answer those before the end. Of course, we would encourage you to get in touch following the webinar with any of the speakers, with your usual Fieldfisher contact, or via eventi@fieldfisher.com. That's eventi@fieldfisher.com. With any questions you have, and we'll endeavour to respond as soon as we possibly can. I'll now hand over to my co-panelists to take us through the approach of their data protection authority and the key issues in their jurisdiction relating to monitoring the temperature of employees and visitors at the company's entrance, data protection requirements with regard to infected employees, including whether the employer can disclose to colleagues that an employee is infected, and the role of any company physician or competent doctor, if relevant, in processing employees' data concerning the COVID-19 emergency. We will hear, in this order, from Francesca, Olivier, me, Thorsten, Manuel, and Zhaofeng. Over to you, Francesca.
Thank you very much, David. Good morning, everybody. So let's start the discussion. I have to underline, first of all, that our common ground for the European countries is, under a data protection point of view, of course, the GDPR, the General Data Protection Regulation, which is, as you know, a set of common rules for the European countries. But it's also a regulation that in the employment context and in the health and safety at work context provides that member states may, by law or by collective agreement, regulate with more specific rules this context in order to protect the rights and the freedom of the employees. So if we are here today around this table, if it's expressly because we have differences, countries from countries, in this context, different regulation of these topics in each country, even more in China. So starting from Italy, we have to analyze 3 levels of regulation in order to answer to the 3 questions of the today's agenda. First, the existing law in this context, existing before COVID and before GDPR. Second, the emergency legislation. Third, the data protection authority statement. Starting from the first, existing law, we have 2 important laws in Italy. For the employment context is the Statute of Workers, which is a law dated 1970. For the health and safety at work, we have a legislative decree number 81 dated 2008. These 2 provisions are still valid, are very important, and contain a principle very important applied by the emergency legislation and by our data protection authority. Emergency legislation. We had a lot of decrees by our government in this period, but the most important document for the discussion of today is the so-called Protocollo Condiviso. That means that it's a memorandum of understanding concluded by the governments and the worker representative during the lockdown, so on 14th of March, and reintegrated after the phase 2 on 24th of April. This MOU has the scope to combat and control the spread of COVID in working environment. So it's very important because it contains provision about temperature. For the first time, we have a rule containing this kind of processing of data, contains provision about fragile employees, about infected employees. So it's the base for our discussion. And we have also the data protection statement, the data protection authority, which emitted a communicated on 2 of March, and now some important facts last week on 4 of May. So starting with answering the 3 questions of today, I would like to stress also that every data protection authority has a different approach in the country, even if we are in the same European Union. It can be more aggressive in terms of inspection, in terms of fines, in terms of suspending its activity during the emergency period. For sure, under an Italian point of view, our regulator is an aggressive one, and I have to say it immediately. So, first question, what about monitoring the temperature of the employees and the visitors at the company's entrance? It's a duty or it's a faculty? The MOU say that the data employer could monitor the temperature, but it's a matter of fact that it's strongly recommended. Why? Because for an employee in the future, it's important to prove to having put inside the company all the necessary measures to combat and control the safety of the employee in the company. And yesterday, the district, the region of Lombardia, where Milano is seated, decided to impose this duty. So there's also some powers given to our region. So from yesterday, for the company seated in Lombardia, it's compulsory to monitor the temperature. How the data employer has to monitor this temperature? He has to process the data. He can record the data only if it exceeds the threshold of 37.5 Celsius. And then he has to retain this data only until the end of the period of the emergency under a data protection point of view, he has, of course, to organize this processing. So authorizing dedicated people to process this data, releasing a privacy notice with the insertion of the categories of data and the legal grounds to process this kind of data. Coming on the second question, can the employer disclose to the other colleagues that an employee is infected? As I said, our guarantee is quite strict and aggressive, and he answered with a simple sentence, no. No, because with a view of the protection of the health of other workers, for our guarantee, it is for the competent health authorities to inform the so-called close contact of the diseased employee in order to implement the required prevention measures. So for the guarantee view, the data protection is a way of balancing the employer power during the emergency period with the employee rights. And this is a different answer compared with the same question analyzed by the European Data Protection Board 1 month ago with a statement of 19th of March, where at the same question, the European Data Protection Board, which is the board of all the data protection authority in Europe, answered that in certain cases where it's necessary to reveal the name of the employees and the national law allows it. Again, I stress the national law in this context. The concerned employee shall be informed by the data employer. So that's a difference between the two positions, and we have to bear in mind this thing. Third question, what about the competent doctor or company physician? Is it important in this moment? For Italy, is the crucial actor under the emergency period. Is, as already provided by our legislative decree number 81 on health and safety at work, an autonomous data controller under a data protection point of view, and he is the only one who can process health data of the employee. It is for the appointed doctor prohibited from informing the employer about the specific disease of the affected employees. He can decide to start tests, to submit workers to investigation, but he cannot say anything to the data employer except the fact that the worker is able or not to work. This is a fundamental Italian principle which has been recalled by the emergency legislation and also by our data protection authority. So now my time is, I think, is finished. I will like to move to France now, asking also to Olivier to express an opinion about the serological test, on which, if I'm not wrong, Neil has expressed his opinion. Thank you.
Yes, thank you, Francesca. And indeed, I'll talk about the serological testing and the blood testing in a minute. So just going back to the three questions, and we will see that there are some similarities, but also some differences between France and Italy. And on some positions, the CNIL has a stricter approach to the one that we've just heard in Italy. So regarding the first question about the monitoring of the temperature and the taking of the temperature of employees and visitors when they enter the premises of the company. Well, first of all, the CNIL always likes to remind us that the body temperature is personal data. So just to avoid any misunderstanding as to whether it is personal information or not. Second of all, with regard to the taking of the temperature, the CNIL takes a very pragmatic and practical approach, and it makes a distinction in the manner in which this temperature is taken and with what kind of thermometer. So essentially, the CNIL says that if the temperature is taken manually by a manual thermometer, for example, that functions with an infrared system, which is what we commonly see on TV, so the one that is brought close to the forehead, that is a manual collection of the individual's temperature. And in that case, it does not constitute a processing of personal data according to the CNIL, and therefore falls outside of the scope of the GDPR. So if that is how companies are going to check the temperature at the entrance, that is permitted. What is not permitted, and this is a key difference with what I have just heard in Italy, is that companies cannot create files and cannot store information regarding the temperature of their employees in files. And therefore, they cannot collect the temperature by automatic means, such as thermometers. Also, what the CNIL tells us is that according to the instructions of the French Health Ministry, the Health Ministry considers that the taking of the temperature is not an essential or the most efficient measure that companies can take. This is arguable and certainly can be discussed, but the logic or the reasoning behind it is that the Health Ministry says it is only one symptom of the illness. And then lastly, the CNIL reminds us that if employees think or know that they are infected, then they should let the company doctor know, not their employer. And I will come back to this in a minute. So regarding the second point, if employees are infected and the employer has this information, can the employer disclose it to other colleagues within the company? Here again, it's useful to remind that there are obligations on both sides, both on the employee's side and on the employer side. As a general rule, employees have an obligation to notify their employer when they are sick. This is a general obligation under labor law. But in normal times and as a general rule, what they have to do is notify and disclose to their employer that they cannot come to work without having to disclose the nature of the illness or the pathology. In light of the exceptional circumstances that we are facing, if employees are working in contact with other employees, then they do have to notify the employer that they cannot come to work because they are infected by the COVID-19 virus. So this is an exception, but it only applies to employees who are in contact with others, for example, working in factories or in supply chains. So for employees who are teleworking, they do not need to specify to their employer if they are ill. Looking at the obligations on the side of the employer now, well, the employer is restricted in the type of information that he can collect and process, and should only be processing information about employees in order to take organizational measures such as teleworking measures or preventional risk measures to avoid a contamination of other employees. Once again, it is not possible for employers to create a data file in which they are going to store all of the health information of their employees. And even regarding at the nature or the type of personal data that they can collect, the CNIL says that this should be limited. So the CNIL here applies the data minimization principle to the date, the identity of the employee, whether the employee is contaminated or if there is a risk that the employee is suspected of being contaminated, and the measures that are taken by the employer. In terms of sharing this information, companies can share the information with the public health authorities only. And therefore, the CNIL says that the identity of the employees who are infected and who are contaminated must remain confidential, and companies cannot disclose this information to other employees. So that answers the second question. Now coming to the third question, which is the role of the company doctor in all of this. As we have seen in Italy, in France, it is a similar position. The company doctor or the company physician has a central key role in the management of the crisis and in the processing of the health data of employees. So the CNIL says that the company doctor has to be at the heart of the organization and the management of the health crisis by companies. The reason being that health data is protected under GDPR, as we all know, and as a general rule, only the doctors are supposed to be processing health information about employees and deciding what specific measures need to be taken. So only the company doctor is allowed to create files and to store information such as body temperatures or a description of the pathologies of the employees. on the question of blood testing, as this was a question that was raised by Francesca, indeed, the CNIL says that companies are not allowed to organize any group screenings of or campaigns in which the companies intend to screen collectively their employees and to do blood testing of all of their employees. And once again, this is something that is reserved only to the medical health professionals, in this case, the company doctor. The CNIL reminds that blood tests or screenings or medical exams are all health-related information and therefore are protected by the professional secrecy that the company doctors are subject to. So in that regard, the answer is no, companies cannot organize blood testing. With that, I finish my section on France, and so I'm going to hand it over now to Thorsten, who will walk you through the position in Germany.
I think it's over to me, and then I'll hand over to Thorsten. So I'll quickly summarize the position in the UK. Thank you very much for that, Olivier. Starting then with the position of the UK's Data Protection Authority, the ICO. The ICO has a reputation as a reasonable and pragmatic regulator, and it has issued and reiterated guidance on its approach during the pandemic, confirming that it intends to adopt the same pragmatic and proportionate approach to regulation. So while some projects, for instance, the investigation into ad tech, have been paused for a period, it has stressed that one of its priorities at this time will be shaping proportionate surveillance, including keeping a close eye on those aspects of the response to COVID-19 which affect information rights such as contact tracing, testing, and other surveillance. So on the law or DPA provisions on monitoring temperature of employees and visitors, the foundational law here is the GDPR. So similar principles apply as in other European jurisdictions, and the overall position is similar to what has been outlined by Olivier and Francesca, but with perhaps a little more flexibility for employers in the UK. In particular, employers must identify a lawful basis under Article 6, which is likely to be legitimate interests, and a condition under Article 9, which is common in the other jurisdictions, and that's likely to be compliance with UK employment law. The employment law in question will in most cases be the Health and Safety at Work Act, which requires UK employers to take reasonable steps to safeguard the health and safety of its workers. In addition, under the UK's Data Protection Act, employers must identify a further condition, which can also relate to compliance with employment law, and have in place an appropriate policy document setting out the way that it would deal with this kind of health data, this kind of temperature checking data. Finally, it's really important to stress that forcing employees to undergo a medical procedure or take a temperature test by, for instance, use of a classic oral thermometer is likely to be a criminal act, so is obviously not a good idea. So some employers will struggle to justify temperature testing, not least because, as Olivier has said, a feverish temperature will not necessarily indicate that someone has COVID-19. They may have a high temperature for many other reasons, including common strains of the flu. That, of course, calls into question the proportionality of that measure. In addition, the UK's government guidance on making workplaces COVID secure doesn't mention this as a suggested step. Again, that calls into question whether it could reasonably be considered necessary to safeguard health and safety, as other measures may be more appropriate. For example, taking measures to enforce social distancing in the workplace and relying on self-reporting and self-disclosure of symptoms and illness, which, as in France, is a requirement in the UK. However, the ICO has recognised that temperature testing might occur in some workplaces, and it hasn't said that it will definitely be unlawful. We also are of the view that the risk of enforcement, particularly where temperature checks are voluntary or semi-voluntary, where the workplace staying open is necessary to provide an essential service in response to COVID, the reasons for it are explained, and it's done in a way that's least invasive, for instance, with privacy screens and administered by a handheld device, as described by Olivier. In those instances, the enforcement risk might be lower in the UK. Conversely, the risk of enforcement on temperature testing would be much higher if refusal to undertake a test would result in dismissal or some other disciplinary sanction. It's vital that employers record their analysis and position in a data protection impact assessment, make sure they're transparent by providing a notice, and ensure minimal data is captured and stored, if any. Moving on to the second question, requirements around an infected employee, and in particular, can the employer disclose to other colleagues that an employee is infected? The short answer is yes. The ICO guidance makes it clear that you may need to tell colleagues who may be at risk, but you should avoid identifying infected employees if at all possible. If identifying is unavoidable, for example, because they otherwise notice their absence or their workstation being cleaned will be noticed, minimal information must be shared, only that which is necessary to protect those who they've been in contact with and who are therefore at risk. You may also need to share details with relevant public health authorities in England, Wales, Scotland and Northern Ireland. And finally, the role of the company physician or company doctor. On company physicians, it's quite rare for companies to be obliged to have a company physician or doctor. That's limited to businesses where, for instance, there's a risk of exposure to asbestos or other harmful materials. Of course, if there are voluntary or mandatory company physicians in place, they should be consulted, but processing of data is not limited to them. If an employer were to decide to carry out serology testing, as discussed by Olivier, for COVID or antibody for potential immunity, they would need to have a qualified healthcare professional involved in overseeing. But as with the position in France, this would be, we would advise strongly against that at this stage. I'll now hand over to Thorsten to hear about the position in Germany.
Thanks very much, David. A lot of all of this is very similar in Germany. So as my colleagues, I'm going to try to focus on the differences. And how I want to do this is I'm going to give you quick answers. I'll try that. I'm still a lawyer, but I'll try to give you sort of yes and no answers to the three areas we're discussing, and then run through risk, because you will end up in gray area necessarily with all of this because the law isn't clear. The law hasn't been built for this. So the short answers are basically that on top of GDPR, let's say alongside GDPR in Germany, we have the Federal Data Protection Act, or BDSG, is the acronym in Germany. And the German lawyers on the phone, the webinar will be familiar with that, and I'll go into that in a moment. The bit about disclosing infected or positive tests, I'd say you shouldn't do so, although I say a bit more about that. It's very similar to what David said about the UK. And the last bit about the company physician, again, I'd repeat the same that David has just said. Chances are you don't have one. If you're a small or mid-sized enterprise, probably you don't have one. So it's not an option. But if you do have one, again, with David, I'd say absolutely use them. This gets rid of a big part of the risk that I'm going to talk about. Before I go into the risk perspective and what you may do, perhaps even outside of what the supervisory authorities think you can do, I have to say, for those people on the phone who are not familiar with Germany's federal structure, this is really important here, because you have to keep in mind, especially if you're working in a multinational group with local offices in Germany, that Germany has 16 federal states and 18 privacy regulators, and a couple more outside of pure privacy that do also touch privacy. And this makes it very difficult to find a coherent approach. And this is rooted in the federal state, and you still have to look at it. When you know where your office is, obviously you'll have to look to your supervisory authorities' guidance. But I cannot and will not go through 18 regulators' guidance here. This is useless for you. It won't help you. It'll just confuse you. And also, I have to say, not sure whether anyone is on the phone, but actually this differentiated approach between the states, and also the vagueness, I'm sorry to say, of their guidance isn't really helpful. They're usually not as pragmatic as the ICO in the UK. In this case, they haven't been irrational, so it's good to see that they allow for reasonable measures. What they have said is, obviously, like many others, that GDPR still applies and that you can take reasonable and necessary measures, and privacy does not stand in the way. This is actually in conformity with the European Data Protection Supervisor at the European Union level. They've stressed that as well, and that's very good to hear. That's actually helpful. But let's move on to some risk points. So one is obviously about the law. You do have to consider generally this BDSG, the Federal Data Protection Act in Germany, and it actually, I think it will help you in this case, at least from the data protection side, and you'll also have to think about the employment side. But the point is, again, as my colleagues have said, you'll be thinking about legal basis to do, for instance, temperature checks. These are on your mind. And my position is personally, as an advisor, and if I were running a business, you'll have to do it, period. The problem is some supervisory authorities in Germany think it's unlawful, at least in certain instances. So if you want to do this across everybody, including visitors, for retail stores, this will be very interesting, then it might be unlawful. And some retail stores are doing this. And the regulators have positioned themselves to apparently say it's unlawful. I think that's not very helpful. And I'd still do this. And I'll try to explain to you why I think this can still be done. So the basis under GDPR will obviously be Article 9, but in Germany, for employees at least, you have this BDSG, and there's a section in there, Section 26, and especially paragraph 3, which governs employee privacy. So this is the transposition, the implementation of Article 88 GDPR in Germany, and this is really helpful whenever you need to process employee data, and that's where you should look to. And I think you can do this. It's easier for employees, actually, and this will give you legal basis if you regard a couple of risk mitigation measures. And that's in Section 22 BDSG, and a couple of obvious things. And I can mention a few in a minute. Trying to put this into opposition to those visitors, let's say, or customers, or suppliers, vendors, what have you, I'd say you can go with Article 9(2)(b). It's a risk position. You have to be aware of that. And as I said, the German regulators are perhaps as progressive as what I'm stating right now. But if you connect the dots and you say that you have to protect your workforce, then why can't you use that argument under Article 9 to say that you can also test and temperature screen visitors and customers and so forth? I'd make that argument. And let's try to think this to the end. Which data protection supervisory authority is going to investigate and fine you if you take reasonable and necessary measures to protect your workforce and actually the society and the visitors? If you get into trouble, please contact me. I'd very much like to discuss this with a regulator. And it's actually, I think, reflected in recital 46, where it says that when processing is necessary for humanitarian purposes, including for monitoring epidemics and their spread, then this is allowed. It's just a recital, but still, I'd very much make that argument. And about risk mitigation, just mentioning a couple of things, and I can send over bullets, just contact me. So you have to respect employment law, privacy rights, transparency, do not use the information for other purposes. Olivier went into that, and use your company physician, as we said before. Don't store the data forever, delete it as soon as possible. If you can, try not to collect personal data at all, like the CNIL has confirmed, and a couple of other authorities like in the Netherlands. Try just to read a temperature. And again, I'd make that argument and just stop there. You know, and if the regulator comes to you and tries to argue about it, I'd very much like to discuss this with them. In the end, coming back to the risk approach. And I think I'm repeating Olivier and my other colleagues. A DPIA, perhaps even conducted if you think you don't have to. I think that's a very good choice because, and this is the central risk point I'd make, I think accountability is your friend here. If you document your assessment and the necessity and the measures you're taking, then put it in the drawer and pull it out if anyone asks. It can be the workforce, can be management, can be a regulator, and then you should be safe for discussion. The door should be open for discussion. I don't see anyone finding you right away if you keep it that way. So that will be it from me from the risk perspective here in Germany, and I'd like to hand over to Manuel for Spain.
Thank you, Thorsten. Interesting to hear you all because we have a similar approach but quite different in some specific matters. On one side, the Spanish authority is aggressive as in Italy, but sometimes pragmatic like in England. So we have interesting solutions in our case. The framework, as in all our cases, is the GDPR, of course, and in Spain also the privacy law 3/2018. But we also have not only the occupational hazards, safe and healthy at work, but also the statements and reports that are being issued by the Spanish authority, by the AEPD, almost on a daily basis. Why? Because the government is issuing new legislation every day, and the Spanish authority is trying to follow up as quick as they can, but it's usually quick and dirty. So not always the information we are getting is the best one or the one we would like in order to assess our clients on what to do and how to do it. Likewise, we have different references from different countries about what we are doing, what they are doing in every country. That makes the mix even a bit worse. So it's sometimes difficult to be accurate when assessing your clients. The actual position of the Spanish authority out of their statements comes from the statement issued on May 12th, where they refer to the strict need to follow the guidelines by the health authorities, the public health authorities, in this case, Ministerio de Sanidad, and always keeping them in track with what's referred in the labor laws on occupational hazards. Meaning that at the end, it's not so much a decision to be taken by each company, but we have to follow the guidelines by the Public Health Administration, and these guidelines must respect all the principles of GDPR on the privacy, especially minimization of data, but can't go against the regulations that protect the workers and their obligations on the obligations for the employers. So, matter of fact, the APD refers directly in the statement both to recital 46, as mentioned by Thorsten previously, which is quite, even if it's a recital, it helps, and also refers directly to Articles 6.1 regarding health as a public interest, and 9.2 on applicable mandatory laws, in this case, safe and healthy on work. So that provides, in a way, the legal framework under which we must follow the guidelines of the Spanish authority. Also, and as happens in Italy, I think that the fact that they've issued some facts, some frequently asked questions, is quite helpful, because at the end, they are providing the factual guidelines on what to do in some situations as a direct interpretation of the authority on what would be the recommended line of action. Getting into the following question, hold on a second. Regarding the capacity of the employer to disclose to other colleagues the infection of an employee, following what David said, I'd say that the short answer is no, but. So instead of being able to do so, the occupational hazard regulation, the employer has both a right and an obligation, on one side to protect the rest of the employees, and on the other one to follow the lead of the public health authorities when a medical emergency, what puts him in a strange position. and always maintaining the principles of minimization of data and proportionality regarding the managing of the monitoring tools. Matter of fact, the Spanish authority has issued a report regarding the different technical devices allowed or recommended for monitoring the employee of the workers, with special attention to the thermal cameras and the fact that the information can be recorded. So they're being quite proactive, providing information on which are the best tools and which is the best way to handle this kind of information. Regarding the communication to the employees, as Thorsten said before, communication must be avoided to employees by the employer almost absolutely. Here, and I jump almost into the last question, the critical figure is the company doctor. The company doctor, one way or the other, is the bridge between the obligations imposed by the public health authorities and the requirements of labor laws for the employer. So we should not provide information about infected employees to other employees, never, and only if we have to. It should be under the guidance of the company doctor when it is convenient to comply with the requests of the public health authorities in order to limit and control the pandemic. So that's a relevant fact. Regarding the role of the company physician, he in fact is the one that has to help the employer to decide which is the best technical device to conduct the monitorization, has to inform the employees on what kind of information is going to be handled and the limits of the processing of such information, and will be at the end the one that shall communicate to the employer if an employee is able or unable to work. Once said so, it is true that mostly with common sense, you must take some provisions that are clear. There is no need to inform someone if a colleague is under COVID. You just need to say that he's not able to work. And if you're not sure if he's under COVID until the physician sends, practices the test to this employee, what you must try is to provide the capacity to remote work when possible to that employee until the final result of the test is available. Okay. When saying so and seeing that the time is running, I think I'm going to pass the ball to my colleague Zhaofeng, because we're all quite eager to know what's happening in China, which have not only much larger experience than us with this matter, but also a different perspective. Zhaofeng, please go ahead.
Thanks. It is very interesting for me to listen. For us, I think for us, the situation is a little bit different compared to what you guys just mentioned. In China, the situation during the peak time, to be honest, in February or March, when we had very serious the virus issue, we saw very aggressive data collection for personal data collection. So even for me, it was not so comfortable. Now things get a little bit better. So this is the background. For us, just for your information, because we don't have the law on protection of personal data. Although we do have the cybersecurity law, which can cover some activities of personal data. So that's the basic background. Also, we have the law on the response to emergency and the law on the prevention and treatment of infectious disease. These are two laws are regularly mentioned for the current situation. So in general, so back to the question
Perhaps just having a few technical issues with Zhaofeng's connection. Zhaofeng, do you want to try again for a second? And if it doesn't work, perhaps we'll go to our question.
Has the
I think we've lost Zhaofeng for now. Hopefully he'll return and we can get his valuable insight, because as I said, China is ahead of us in terms of its return. Perhaps in the meantime, we could spend a couple of minutes on a question that's come in ahead of time from one of the participants. I'd suggest that we deal with this in the same order as before, so starting with Francesca, then Olivier, me, Thorsten, Manuel, and Zhaofeng, if we're able to get back to him. The question is, does an employer have a duty to involve workers' representatives in connection with adopting anti-COVID health and safety measures? So over to you, Francesca.
Thank you, David. So to be honest, the answer is that it's a faculty strongly recommended. The MOU provides that it's compulsory to appoint a committee in the company, and one of the workers' representatives must be part of this committee, which doesn't mean that you have to obtain the consent of the work representative, but it's an important point. Different point is if you want to implement devices that control the activity of the employee for the COVID. This is a different point, and if it's the case, you have to obtain the consent of the worker representative.
Yeah, so in France, the role of the employee representative bodies, this will depend obviously on the size of the organization, and the obligation to have a representative body in the form of a works council, for example, is not obligatory for all companies. So the response to that will first of all depend on the size of the company. But typically under French labor law, and this is a more specific issue under French labor law, the employee representative bodies have to be involved, either informed or consulted, if there are any measures that are taken that are going to impact the working conditions, such as the safety and the security of employees. So in that regard, yes, to the extent that companies are envisaging to adopt certain measures that may have an impact, and it could be, by the way, the introduction of new technologies or the the use of existing technology for monitoring purposes, for example. If this is done in the context of combating COVID-19, then yes, it may be a legal obligation to at least inform the employee representative bodies.
Thank you, Olivier. So similarly in the UK, there's a pre-existing labour law requirement to consult with representatives on risks identified by health and safety risk assessments, which are mandatory, and on some other health and safety matters. And specifically in respect of the COVID-19 pandemic, the UK government suggests that employers must provide clear, consistent and regular communication, and must engage with workers through their existing communication routes and worker representatives to explain and agree changes in working arrangements. So practically that means updating risk assessments for the return to work, if that's going on, and consulting with any pre-existing representatives in place. Over to you, Thorsten.
Yeah, similar to France and the UK. Here in Germany, many companies have works councils, and they have encompassing information rights, so you do need to inform them about what's going on in terms of COVID-19, and chances are very high that actually you need the consent in some form. Usually this means entering into a works agreement with them, and you have to factor in this takes time and resources to get on paper and get done. So think of that point early on, whatever you do.
From a Spanish perspective, we, as happens in France and in Italy, we have, not all the companies have a work council or representatives, but in fact there's pre-existing law that imposes the fact of being able to share risks regarding work environment with the work council. In any case, and more than strongly recommended. I think it's at this time absolutely necessary to go by the hand with the work council and working representatives, because things are changing day by day, and you need to be fully aligned with them in order to be able to implement them and control the pandemic. So if it has to be a recommendation, I'd say that yes, indeed, you do have to check with the working representatives, because at the end, they're the ones that will answer the questions of the employees and that will help the companies to get out of the crisis without conflicting rights between employers and employees.
Zhaofeng, perhaps you could, it looks like your connection's stable, which is great. Perhaps you could give us a 2-minute overview on the temperature testing and consultation, if at all, in China.
Yeah, so the temperature, the testing of temperature is yes. And because the law requires the employees to make sure if they find any suspicious case, they have to report to the authority. So although I heard what you guys said, testing temperature is only one way, and it's not, maybe it's not most sufficient way or good way, but in China, it is basically the only way. So yes, and for the data, for the employers, for the second question, they shall not disclose the information of any infected employees to other people, except the authority. So basically quite similar like David, what you just said in the UK, they should avoid any, for any possibility to disclose such information. But sometimes, you know, you only have 2 employees and one infected, it's inevitable the other one won't know. So that's the extreme situation. For the third question, because I don't think it's very relevant for China, because we don't have the company doctor, so this we don't know how to do it. But normally we think these doctors should report to the employers rather than the employee. So basically, in any event, such data shall be confidential. That's the basic principle, unless you have to disclose to the relevant authority. That's a basic line.
Thank you, Zhaofeng. Really interesting analysis. I think we've got time for one final question, which I might ask Thorsten to answer on behalf of all of us, if at all possible. We've had one question from an attendee, which is what measures should be adopted by the employer if it detects that an employee has a temperature that exceeds the threshold at the entrance? Thorsten, thoughts?
Yeah, that's a very short answer. Send them away. It's it's not as bad as it sounds. Maybe the details are a bit tricky as everything in COVID-19. So you need to make sure, also under employment law, I guess, not to discriminate them. You know, don't shame them publicly. Help them go away in a very normal fashion. Again, don't disclose their name, and then, if in any way possible, try to find an amicable solution. And by that I mean that you have to help them to work from home, to see medical advice, and to put them on sick leave or whatever means is available in your country. It's pretty obvious, and actually most of that also applies to other visitors, non-employees.
That sounds very sensible and certainly similar to what we see here in the UK. So it's almost now time to wrap up. Although we've looked today across a variety of regimes, hopefully you've seen some similar themes emerge around the importance of taking some steps to safeguard employees' health and safety, and the need for proportionality, transparency, and prompt deletion of employee data. Of course, there are, and we hope we've clarified, some very important differences, which means there are particular issues to navigate in each of the jurisdictions, even within Europe, and plenty to think about before implementing relevant measures, if at all possible. Thank you for joining. I trust this was helpful and it gives you some of the answers you were looking for. If you still have questions that we didn't answer or want to speak with us about the issues we did cover, we'd be delighted to hear from you. Please contact any of the speakers, your usual Fieldfisher contact, or use eventi@fieldfisher.com. That's EVENTI@fieldfisher.com, and we'll endeavour to respond as soon as we can. As a reminder, we'll send a link to a recording very soon, and do look out for more blogs on the Fieldfisher website and for our other webinars designed to help businesses deal with the COVID crisis. All that remains for me to say is thank you once more. Goodbye and take care.